Okay, let's unpack this one. What happens when, a routine traffic stop kind of snowballs?
Snowballs is one way to put it.
Right. Involving car tags referencing the Bible, claims of divine right to travel, and it ends up as a federal civil rights lawsuit. A pretty complex one.
Absolutely. And layered with some deeply held, maybe unconventional religious beliefs.
We're diving into a plaintiff's motion here. It's filed in a U.S. District Court in Tennessee. Basically, the plaintiff is pushing back against the police department, trying to get his case dismissed.
And the listener who sent this wants us to get into the key arguments, the plaintiff's unique perspective.
So our mission, pull out the most important nuggets from this pretty dense legal filing.
Well, right off the bat, this document doesn't read like your standard legal brief. The plaintiff, Joshua Haltom, he identifies himself sui juris.
Meaning acting for himself, no lawyer.
Exactly. But also as an ordained clergy member. And, well, he goes further. Using spiritual titles. Things like ambassador for and citizen of heaven. Also, minister for the Temple of Light and Life.
Ambassador for heaven. Okay, yeah, that signals this isn't your typical lawsuit.
And he states he operates under common and ecclesiastical law. He makes it really clear he is not a corporate entity dealing in commerce.
So that whole framework is crucial for him.
It's central. It leads to his core assertion. He travels by right, not by privilege. That single idea, that's the bedrock for everything that follows, especially the incident itself.
Okay, let's get to that. May 6th, 2024, Henderson, Tennessee. His wife's driving his car.
And the vehicle, as you mentioned, was marked very specifically.
Right, the tags. What were they again?
1611 KJV not for commercial use clergy with a white peace flag. So according to the plaintiff, an officer stops them and allegedly seized my private property, specifically the vehicle tags, without due process or consent.
Okay, seized the tags.
Okay.
And he doesn't mince words about how he saw that action.
No, he calls it robbery and assault under the guise of color of law. He sees it as way more than just a traffic issue. It's an attack on liberty, maybe even a violation of divine mandate because of his religious identity.
So that's the spark. No, the legal fight. He's in federal court.
Seeking redress for unlawful coercion, deprivation of freedom to travel, and infringement of religious liberty. All done, he argues, under color of law.
Abusing state authority, basically.
Right, and he's using the standard tools for that, like 42 U.S.C. Section 1983. That's the law letting you sue state actors over constitutional rights violations.
And the right to travel comes up.
Big time. He argues it's a fundamental right, citing cases, and that it's being illegally conditioned on buying state stuff, like registrations.
But the religious angle, that seems like the core of his unique stance.
It absolutely is. He claims First Amendment violations, free exercise clause, but the real insight, I think, is how much he leans on Ballard v. United States.
Ballard. The case saying courts can't rule on whether religious beliefs are true or false, only if they're sincerely held.
Precisely. He uses Ballard like a shield for his self-definition, his interpretation of the event as spiritual trespass, even his use of, biblical analysis, 1 Samuel 8 on tyranny, to frame what happened.
So Ballard protects his whole worldview in court.
That's the argument. He even suggests spiritual harm should count as a real injury the court can recognize, because it stems from messing with his protected religious identity and travel.
He also mentioned the Establishment Clause.
Yeah. Arguing the police action was improper government meddling in his private religious sphere, blurring church and state lines, basically.
Okay, so that's his case. How does he deal with the defense trying to shut it down?
He hits back on procedure. Specifically, he accuses them of repeatedly calling him a sovereign citizen.
Even though he rejects that label.
Strongly. Calls it a misnomer and oxymoron. Legally wrong, he argues, citing cases. He says it's prejudicial language, like under Rule 403 for evidence, just meant to poison the well and get his claims dismissed without looking at the substance.
So he feels they're ignoring his evidence and just name-calling?
Pretty much. He suggests they might be violating Rule 11, the good faith rule for filings, and that it could affect things down the line, like summary judgment.
Okay, so after all that, what does he actually want the court to do?
First, deny the motion to dismiss or strike it. He wants an injunction in order stopping them from making financial demands or messing with his travel.
And damages.
Compensatory damages. And it's specific. $2.2 million USD, or the equal value of pure Cambridge Troy silver.
Pure Cambridge Troy silver. Okay, that's definitely not standard.
Not at all. He also wants a court declaration that his clergy ID is valid. And maybe most uniquely, he asks the court to look at terms from his diplomatic proposal.
Diplomatic proposal? Like what?
Things like transparency, immunity for telling the truth, ambassadorial oversight, even Zohar offerings as potential remedies. And he links these back to Ballard, suggesting they fit within his protected religious framework.
Wow. Okay, so wrapping this up. What does this really mean for you listening? This case forces the legal system to wrestle with some really tough questions, doesn't it?
For sure. How do courts handle claims rooted in these very unconventional spiritual identities when they clash with state authority? Where's the line between protected religious expression and claims that seem to reject basic laws?
It leaves you with something to think about. How should this system balance respecting someone's deeply, sincerely held beliefs, even if they seem way out there, with the need for laws to apply uniformly to everyone?
Yeah.
Where do you draw that line?